So we were giving we had, on the last lecture, we had covered field 106. 106. Where special knowledge, especially within the knowledge of an accused person. So the burden will be upon the accused person because the knowledge is within the knowledge. So when any fact is specially within the knowledge of any person, the burden is upon him to prove it. Normally, when the prosecution has filed a case against the accused person, under the criminal law, the normal rule is that the prosecution has to lead evidence, prove the charge beyond reasonable doubt. Because after the completion of the filing of the charge sheet under 173, the commencement of the trial take place after committal proceeding under 209. The court of sessions, if it is a session triable matter under 225, the session judge will take the cognizance, and charges are framed under the provisions of 226 with 226, 227. You know that here, that is the place. Now, in a matter like this, where the burden is upon, especially known to certain fact, the accused has to prove. Some of the examples with regard to within the knowledge is accused taking the plea of alibi under section 11. He will take up the plea that at the time of the commission of the offense, I was not in Mumbai, I was in Dubai. So the prosecution need not start leading evidence. So here the accused first has to prove that he has been falsely implicated. He was not the person. So evidence of alibi is a special knowledge within the knowledge of the accused person. The burden will shift to him. Then again, the evidence with regard to mens rea under section 8, motive, preparation, conduct पढ़े आपने, and section 14 के अंदर good intention, bad intention, ill intention, motives is led. When you take up whether what was the motive of the crime, the accused will plead that here prosecution proves if the want of mens rea is pleaded by the accused, he must prove that it is specially within his knowledge. Because there was no mens rea, he will, of course, mens rea is not a condition precedent, but he's taken the plea that here, I have not committed the murder of the victim. I have been impleaded wrongly, and there was no reason for me. There was no motive on my part to implead him, to kill him. So that motive aspect, he should be allowed to lead evidence in the regard. Okay. Then burden of proving the transaction. Then you must be knowing also the doctrine of res ipsa liquidator. That is, generally speaking, in the case of negligence, a burden of proving negligence on the part of the defendant lies on the plaintiff. If you're trying to prove the res ipsa loquitur, that is the maxim which is normally used in the law of tort for proving negligence. And now it lies on the plaintiff. But in case where the facts speak for themselves, showing negligence of the defendant, if the defendant has committed the act of negligence, then the burden will shift upon the defendant to prove that he was not negligent. Abhi accident ho gaya road ke upar. So suppose I was driving a motor car, you were also walking in a wrong direction. So I will be prosecuted for negligent driving, and I will take up the plea that here, no, the accused person was walking in a wrong direction. So suppose even a suit is filed and it will go to the Motor Accident Tribunal cases under the MV Act. If a suit is filed for further damages going to the civil court, then the burden will shift to the person who takes up the plea, I was not negligent. So that is the doctrine of res ipsa loquitur. That is it. Then the burden of proving negligence of a carrier. You know that there are carriers also when the goods are carried at the risk. You know that. Then special facts, circumstances under which the consignments were handled is known to the railway administration. Therefore, a special burden will shift upon the administration to prove. So railway administration had the duty of producing all the available record and their non-protection justify the raising of an adverse inference against them. So they are duty bound to take care that the goods were not mixed of the plaintiff and defendant or defendant with other people's here. What kind of a due and care you are taken here? So that was within the special knowledge of the railway administration. Then, in some cases, burden of proving the death of a person unheard of. Uh, Somebody is, we just following the examples, somebody has not been not heard in cases of inheritance under the Hindu or Mohammedan law or any other law, any other law. Individuals, yeah, the individual deaths are very important facts. So unless your succession doesn't start, you cannot prove the will, you cannot prove the heir, you are the heir entitled to right title interest unless you prove that your ancestor is dead. So the burden is will be upon you. You are a person raising the plea that my grandfather, you have filed a suit for administration, you have filed a suit for succession, a suit for claiming right title interest from the deceased person. पहले बताइए कि the person was a dead person was your relative. When did he die? So the burden will be upon you under the law. Then you are required to give a satisfactory explanation for injuries on the dead person by the accused person. So in a criminal trial, how did the accused person is having injuries on his body? हाँ? अगर तुमने गुनाह नहीं किया है तो आपकी बॉडी के ऊपर इंजरी कहां से आ गए? So the burden will shift upon the accused person to explain how these injuries on his body, whether it was a self-defense or whether it is some inflicted accidentally some other place. Otherwise, the court will presume that there was a scuffle between him, between the accused person and the complainant, the victim, and as a result, whereof the injuries were caused. So the burden will shift upon him to prove that it is not. Now, we have a illustration of the person charged with a traveling without valid ticket under section 106 here. When a person is charged with traveling on a railway without ticket, the burden is on him to prove that he had a valid ticket. The burden, the TTE is not going to come and depose before the court of law. This man boarded a train from Andheri and Churchgate, I caught him. So the fact that he took the ticket from the Andheri railway station is upon the person who is arrested, the person who has been detained by the TT. The TT is not expected, the prosecution. So it's a myth that in every matter it is not the prosecution liable to prove before the court of law. Okay, then come to section 107, 106. May anybody has any doubt, you can ask me. If you have no doubt, 107. Burden of proving the death of a person known to have been alive within 30 years. 107 deal with a case of a person who is dead and gone 30 years ago. 30 years, you file a suit here. My father or grandfather died about 30 years ago. He left behind a document which is a 30 years old document. A 30 years old document can be received in evidence under section 90 of the Evidence Act. Isn't it? The court will presume that here this is the court may presume yes the document, but the burden is upon you to show that here 30 or 40 years ago my grandfather died, and you may lead evidence in a tomb, or you may lead evidence of his passport, you may lead evidence from the school record, you may lead evidence from the newspaper of neighboring examining kisi ko, and he was dead, and you are the only ancestor claiming right title interest, or you are one of the person along with the defendants you are seeking a claim, and your brother and sister or your uncle were acting in a fiduciary capacity, they were trustees, they are depriving your right title interest. So the burden will shift upon you to first prove that the ancestors were dead 30 years ago. Unless the other side takes up the plea, my ancestors are alive, the suit is not maintainable. So 107 ke andar, the person who takes up the plea that the person is dead and gone 30 years ago, he is not alive. If the defendant takes up the plea, the government administration 30 years, nahi, zinda hai wo, then the burden will shift upon him. So 108 speaks of a case of a person being alive who has not been heard of 7 years. So I gave you an example of a gentleman who goes to pilgrimage and doesn't return back. So more than 7 years have happened, his family members, the wife and daughter, the family members filed a application for withdrawal of petition, claiming petition, whatever the benefits entitled to deceased person. So the government will ask him, the person should come personally to claim the benefits under the Pension Act or under the Provident Fund Act. We cannot give it to the heirs. They will have to prove that within 7 years he has not been heard of, he had gone to pilgrimage. So the evidence of a family member is the best evidence, the law says that. So these are the person from whom naturally heard of a person. Those person who would naturally have heard of are leading evidence. They are leading evidence to place on record the gentleman, the husband of father, has not been alive. He has not been heard of for 7 years. Of course, he had gone to pilgrimage, not returned. We filed FIR. We placed newspaper advertisement. We also had been to the local police station where he had gone, but they had no proof. It is possible he must have dead and gone in a valley while crossing the river, while walking, because these are all difficult mountainous areas. It is not possible. 7 years have elapsed thereafter. So you file a suit for declaration claiming his right title interest. Claiming interest that the other side will take up the plea. No, he is alive. You as a widow, as a child and daughter, claiming a right title interest. You may claim a succession. You may claim a letters of administration or probate. The defendants will take up the plea. No, it's a false statement. He is alive. So when he is alive, you lead evidence. So whichever person takes up the plea that year, he is alive, he is required to discharge his evidence. He is burdened under section 107 of the Act. So 107 deals with the death of a person known to have been alive for 30 years, and 108 deals with the death of a person alive who has not been heard of 7 years. So these examples are very common in especially property matters, suit for administration, suit for succession, when suit for will is claimed under the Indian Succession Act. Okay, then 109 deals with the relationship in cases of partners, landlords, tenant, principal agent. Yeah, as I told you that here under the Transfer of Property Act or rent control legislation, it is not open for a tenant to dispute the status of his owner. Having paid rent earlier, last succeeding 3-4 years, and you cannot take up one fine day that you have given me a legal notice to pay the rent. I do not accept you as a owner. So you are estoppel. There is an estoppel under the provisions of section 116 of the Evidence Act, which we'll go through subsequently after this. We say that here it is not open for the tenant or open for the licensee uh, who you are a permissive occupant. Have you come into possession with the permission of the landlord and with the permission of your license? You cannot tomorrow dispute the fact that who are you. You cannot file a suit for declaration that you don't recognize him. So that kind of, if you take up the plea that he has ceased to be the owner, there are cases of adverse possession under the provisions of Article 67 of the Limitation Act, where if a landlord has not bothered to claim rent for more than 12 years, and you are a person paying taxes, and there are cases come to the court, Supreme Court, and various matters. After 12 years, even a tenant or a licensee who has been in continuous possession and not paid rent to the landlord, anybody can claim adverse possession. He may take up the plea. I dispute his ownership now. I have become the owner by adverse possession. So in that event, under 109, you have to lead evidence. But normally, when you take up the plea, that normally when relationship is subsisting under the rent control legislation or under section 105, 106, 107 of the Transfer of Property Act, during the continuance of the relationship, you are not permitted to deny the status of your landlord. Please note that here. But you can only deny if for more than 12 years your landlord has not collected rent and the landlord has not exercised his legal right either to evict you. His rights are extinguished under section 27 of the Limitation Act. You know that very well. And you have a right to claim adverse possession under Article 64 and 65 of the Limitation Act. Please note that here. That is the situation where you can deny. Yes, I dispute I become owner by adverse possession. I am entitled to claim legal right as a owner thereof. Otherwise, if you have been regularly paying rent, contractual rent, and tomorrow you cannot turn around and say that here I dispute your relationship. Because you are liable to be evicted on the ground itself, section 109. 109 also contemplates a situation, relationship between license when principal and agent, which are contemplated under the Indian Contract Act. As you learned that here, the 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 principal is liable for all acts of the agent, because the agent is presumed to be having authority. He's having a implied authority or a express authority. If you are given a power of attorney to your servant to deal with your property, sell your property, administer your property, and he is managing your property on your behalf. So he is collecting rent from all your tenants, 100 tenant licensees, paying taxes to God, isn't it? So under the eyes of law, he is your agent. When a agency is revoked for breach of trust or for not giving you rendition of account, you have a right to give a legal notice and terminate the agency. So when suppose if one of the banker has filed a suit against you and the agent, that your agent has withdrawn an amount of 10 lakh rupees and not paid the amount, you may take up the plea that here, my agent, I never authorized him to, first of all, withdraw this amount, and his agency, which was granted to him earlier, has been terminated by giving a newspaper advertisement. So when you take up the plea that here termination has taken place under 109, it is the burden is shifting on you to prove that the relationship of agency is terminated. But if the agent say that no, I am duly empowered, I have an implied and authority under the Indian Contract Act, express authority is there, also implied authority is there. Because by virtue of, if there are too many landlords of the property, if the four people are joint owners, one landlord can file a suit. It is not necessary under the eyes of law, all must sign the plan. So one of them take up the plea that I have not given my consent, but the law recognizes the deemed consent. The deemed consent here, and whatever act the co-owner has done is binding upon the other co-owner. So your remedy will be, suppose a tenant or a licensee has been evicted by virtue of a decree passed by the court of law in a suit filed by one of the co-owner. He has taken possession. The second co-owner cannot tell the tenant, you give me possession. Ultimately, you have to go to the court of law and discharge your burden. So in cases of termination of agencies, if the agent takes up the plea, my agency is not terminated, he will have to lead evidence. If the principal takes up the plea that here I have revoked the agency for non-rendition of the account, I have prosecuted him under 406 and 409, then the burden will be shifting upon the principal to law you. So it's a matter both in civil cases and criminal cases you invoke it. 110 में आ जाइए, burden of proof as to ownership. So when a question is whether any person is the owner of anything of which he is shown to be in possession, the burden of proving that he is not the owner is on the person who affirmed that he is not the owner. So A and B are litigating before the court of law. So you have filed a suit under section 6 of the specific relief act that I have been in possession, occupation, enjoyment of the premises for the last 15-20 years. Okay, your possession is known to the entire world. And you may take up the plea that year. Last month, I had to go to pilgrimage. I trusted my next door friend to keep my chavi and take care of it. I trusted him, give it up. वो क्या करेगा, आपकी ताला तोड़ के कब्जा कर लेगा and property सब snatch कर लेगा. So you file a suit under section 6 ki I am the real owner, I was in possession, I have been dispossessed without due process. So, so you seek either remedy is to file a suit under section 6 of the specific relief act on the basis of mere possession, that is your title, or you can file a title suit under section 6 subclause 4 read with section 35 of the specific relief act for a declaration that I am the owner. If that is so, if the defendant is disputing no, you are not the owner, the burden will shift upon the defendant to prove that here that he was not the owner. That is how the situation. So you all know the consequences of the provisions of section 6. Both summary remedy would lie within 6 months and a substantive suit would lie within 12 years from the date of disposition. So the burden will shift here depending upon who is suing what. Okay. Then 111 speaks of proof of good faith in transaction where one party is in relation to active confidence. Now, this is a provision uh, between two persons who are acting in fiduciary capacity. Let us see that here. Where there is a question as to good faith of the transaction between parties, one of whom stands to each other in a position of an active confidence, the burden of proving that good faith of the transaction is on the party who in a position of active confidence. This is the normally uh, the elder brother in a family or a manager or a karta of a Hindu family is a trustee acting in a fiduciary capacity. He is not supposed to misappropriate the share of the other members, the co-pastors, isn't it? Now let us see the illustration. The good faith of a sale by a client, the good faith of a sale by a client to attorney is in question in a suit brought by the client. The burden of proving good faith of the transaction is on the attorney. So relationship between the advocate and the client is always based upon a fiduciary relationship. It's based on trust. Advocate is not supposed to misappropriate or act in contrary to the interest of a trust. Then the good faith of a sale by a son just came of a age to a father is in a question in a suit brought by son. The burden that the good faith transaction is on the father. So the father has put the son in possession of the property, his property. He'll say, in good faith, acting, trusting my son will do. So whether it's a good faith or a bad faith, he will take up the plea that my father has told me. In the earlier case, the burden of proving good faith of transaction is on the attorney. So the good faith of a sale by the client to attorney is in because advocate attorney is not supposed to purchase the property of the client. Even you cannot be an auction purchaser under the execution law under Order 21. But if you had sought the permission of the court and purchased it here, the burden will shift upon you that on account of good faith you did it. There was no malice on your part. There is no ill motive on your part in doing the transaction. The transaction may be irregular, but it is not illegal. Okay, that is the contention before the court. 111 111A पे आ जाइए अभी. Yeah, presumption. Yeah, presumption as to certain offences where the person is accused of having committed any offence specified in subsection 2 in any area declared to be disturbed area under the enactment of the time being in force, making provision for the suppression of disorder and restoration of maintenance of public order, or any area in which there has been over a period of more than one area extensive disturbance of the public peace, that is shown that such person has been at a place in such area at a time when firearms explosives were used, or from the place of attack, or resist the members of any armed forces or forces charged with the maintenance of public order and discharge of duties, it shall be presumed, unless contrary is shown, such person has committed the offense. The offenses following, namely offenses under 121, 120A of the Indian Penal Code, criminal conspiracy, abetment, 122, 123A. Now here normally under the Indian Penal Code, the burden is shift upon the prosecution. But here the offenses are against the state. In a case where the offenses are of sedition or under the preventive detention, National Security Act or Unlawful Possession Act, where the government is now arresting several persons, putting them in jail, even know that even bail is not granted. So the burden is shifted here, unfortunately, upon the accused person to show that he was innocent. So the government presumes that he has committed the act of sedition, he has committed the act of conspiracy, waging a war against the country. So in my submission, this is a very harsh provision against the accused person for the reason that simply in a situation like public order, government will not be in a position, witnesses are not ready to come forward and depose. The law presumes that they have been arrested rightly, and to prove the innocence is upon the arrested person. So very unfortunately, very wrongly, burden is placed upon them in Mokoka crimes and all crimes which are not within the falling within the ambit of special acts, especially the special acts. Okay, 111A. Yeah. Yes. Now next is a birth during marriage conclusive proof of legitimacy. Now this I had discussed with you while discussing section 41, 42 of the Evidence Act. May presume, shall presume conclusive proof. I won't much waste time. 112.13. So here the law presumes that here, it presumes that here conclusive proof, 112 के अंदर presumption about legitimacy of a child. So, if it is proved that here the particular period is 280 days after the dissolution, mother remaining unmarried, any birth take place, the child is valid. अभी इसके लिए DNA वगैरह कराएगा, husband will take up the plea. I never had an opportunity to have any intimacy with my wife, and I don't know how she conceived. I was not in a native place or gaon. I was in a foreign country. Then in that event, the burden is upon him. That burden is upon him to show that he never had intimacy, and the child which has been conceived doesn't belong to him. So there's a technology of DNA. बहुत कुछ हो रहा है अभी. Now government is now amending the provisions of CRPC Evidence Act. This may be suggestion हुआ है. Let us see what happens. So 113 के बारे में, there are territories which are sought to be conclusive proof annexation of territories after the our independence under the State Reorganization Act. Several princes and the Rajas and Maharajas and Nawabs have amalgamated and joined the territories of India. There are more than 600 states in India. So the joining of the Indian Union is accession, and the court, it's a conclusive proof that they are part of India. That is India, which is Article 1 of the Constitution of India says India is a union of states, isn't it? So all these unions which have been joined the union, it's a conclusive proof. It cannot be disputed at the end. 113 ये देख लीजिए. Presumption as to abetment of suicide by a married woman. When a question is whether a commission of a suicide by women has been abetted by her husband or any relative or husband, it is shown that committed suicide within a period of 7 years from the date of her marriage, and a husband, such relatives, husband subjected to a cruelty, the court may presume that having regard to the other circumstances of each case, the suicide has been abetted by husband and other relatives of husband. Now, this is normally, see that for the purpose of this section, cruelty shall be the same in 498A of the Indian Penal Code is a section which makes the offense cognizable and punishable: cruelty, demand of cruelty, harassment. Now, if unfortunately due to harassment, cruelty, the wife commits a suicide within 7 years of the marriage, the burden is shifted upon the husband to show that he had no role to play. Otherwise, the court presumes that she committed suicide being instigated by the husband. So for the provisions of 309 IPC lagega burden, and the prosecution need not prove this case, and it is the husband and the relative will be held up and prosecuted in this matter. Please note that here 113A is also is a shifting of the burden in many cases. 113A, 113A, that is then for the earlier cases, you need to see the DNA and RNA test. Some judgment of the Supreme Court are there. You may go on the net and see that. You come to know what is the effect of DNA test. Probably the government is going to regularize it now, amendment ke baad. Okay, and presumption as to abatement of suicide to ho gaya abhi, then abatement of suicide. Where the husband and relatives can be prosecuted. Now, so far as 113B, presumption as to dowry death. 113B is also very important. When the question is whether a presumption has committed, when the person has committed a dowry death of a woman and shown that soon before the death, such woman has been subjected to by the person to cruelty or harassment or in connection with the demand of dowry, the court shall presume that such person has caused the dowry for the purpose dowry. Now here यहाँ पे 113B में the year is not bracketed. Now 113A के अंदर within 7 years, but dowry demand can take place anytime. There is no time limit for it. A person may become greedy even after 7 years. If due to continuous harassment under for dowry, the wife maybe after 7 years, 8 years, 9 years, 10 years commits a suicide. So the law presumes that here the the prosecution may have placed your letters or email messages or text messages, husband demanding money, and it was cruelty. And the demand of dowry is under the Dowry Prohibition Act is an offense. And the woman, as a result of unable to bear the trauma, unable to bear the torture, unable to bear the atrocities, committed suicide. So the law presumes that here it is the husband and the relatives are responsible. The burden, the court presumes them guilty. So in the when a charge is framed, ultimately the husband has to first step into the box. So the prosecution need not. The police officer will submit the charge sheet under 173. The court will frame charges under 225 and 26(7) of the CRPC. The burden of that I have not committed the crime. So various alibi, you can take up the plea, no mens rea, all these factors will come into play. So the burden will shift upon you, not the prosecution. You can bear. 114, I need not repeat again, read. We had done it in the first lecture. These are the examples with regard to the may presume, isn't it? Kumar, do we need to read this 114?
I should skip that.
Yeah, 114, we are done. Whenever we have spoken about the may presume or what are the various illustration when the court presume, this was the first lecture, first, second, third lecture, and I won't repeat again. Okay, is a very important topic, but by the examination point of view, please remember the illustration. Illustrations are very important. If any problem, if they all get back to me, I will again recapitulate. 114 ये पे आ जाइए. Presumption as to absence of consent in certain prosecution for rape. This is important. 376 cases में. In a prosecution for rape under clause A, B, C, D, M, 2 of 76 Indian Penal Code, where sexual intercourse by the accused is proved, and the question is whether it was without the consent of the women alleged to have been raped. Such women state that in her evidence before the court, she did not consent. The court shall presume that she did not consent. So here, sanctity is attached to the statement of the victim, and you are not permitted to lead evidence in rebuttal. You cannot cross-examine her on this point of consent. Though you may lead in your own evidence to play that here, the relationship, the act was a consensual act. It was a fornication. We were living together. In fact, it was a breach of promise. It was not a rape. That you may lead your own evidence. You can put up your case in cross-examination to her. I put it to you that between you and me, there were good relationship. You and me were very good friends. I had promised you to marry. I did not marry. As a result, I married somebody else and you got jealous. Out of jealousy to teach me a lesson, you have filed this false rape case against me. In fact, whatever relationship we had was a consensual relationship. So that part of evidence you must lead rebuttal, but the burden is upon you. Please note that. But that doesn't mean that you have no right to lead evidence in rebuttal. You have a right to lead evidence in rebuttal. In the line I suggested to you. Please note that here you have to step into the box. Tell the court of law. You should also tell the court the evidence of the victim, the complainant, that she did not consent is wrong. वो तो बोलना पड़ेगा आपको. You have to refute it. She's wrongly giving putting the blame on me. In fact, it was a act of fornication, consensual act. So the court may accept your evidence. It's not that here. Nowadays the trend of the courts is that here in cases of rape, where long relationship between the boy and the girl, resulting in filing of rape cases. It's a case where unfortunately the women being it's a case of a sarg rape. You may say that you promised to marry, did not marry for A reason, B reason. In such a scenario, the women launching prosecution against you under the provision of section 376 for rape. So the court normally assumes that the rape has taken place, penetration has taken place. So she has made a statement that I have not given consent. Then the burden will shift on you. She need not. The court is not placing the burden of the hardship of a burden upon the girl. She only has to prove before the court the sexual act has taken place, penetration has taken place, medical evidence is before the court. That will show the semen test was done, and the clothing of the girl and your own pant and shirt were found with your semen. That itself is sufficient to show rape. And the only thing you can take up the plea that here it was a consensual act. She, in fact, has given the consent. Our relationship, she has been my close friend from my college days, school work. We were working together. We have been together. And in fact, I was supposed to marry her. And we were very cordial. But unfortunately, we came from a different family background, different religious setup. My family people did not agree for the marriage. And unfortunately, I could not marry. And whatever acts we have been together. We were in a compromising position several times in a hotel, in so many places. It's a consensual act. Now the reason that I got married to somebody else as a retaliation, she has filed the present complaint, which is unfortunately which is a misguided one, which is an act of retaliation, where in fact she has been a consenting party. But that you have to put her in her cross examination under section 145, 146 के अंदर and 157, 154 में you must put in your cross examination. अगर if you don't put it, you will be in trouble. So you must discharge your burden. Okay, please note that here. 115 to पढ़ाया था मैंने आपको. Estoppel 116 also. The representation given by A at the time he was not the owner. Your grandfather had made a will in your favor bequeathing property. At the time, merely because you are a property bequeath हो गया, आपने property मेरे को बेच दिया. So I believing that you are the owner, I paid you consideration. Then you told me, wait, I cannot sell the property right now. It is only after the death of my grandfather who has bequeathed the property. Then your grandfather dies and you file a probate and you become the owner. Then I tell you, please, what about the promise to sell the property? The value of the property is gone up from 1 crore to 5 crores. So you have a change of heart and you are selling the property to somebody else. You will take up the plea. No, at the time of the contract, I was not the owner. So how can I sell you? There is a estoppel against you. So I mean the defendant has a right, the plaintiff has a right to file a suit against you for specific performance under the of the contract, placing on record that there is a estoppel against you. There is an estoppel against you. So you cannot take somersault. Okay, that is one. 216 is a case I already discussed where landlord and tenant licensors cannot deny the relationship of a landlord tenant. Existing relationship, having paid rent, having paid compensation regularly, it is not open for you. The only case where you can take up the plea, deny the relationship, if for 12 years rent is not taken from you, you have been paying taxes and no action taken against you by the landlord, then the landlord's rights are extinguished under section 27. Because under the Limitation Act, the landlord must file a suit for eviction within 12 years under Article 67, 68 of the Limitation Act. If he chooses to not to file a suit against you, then there's extinguishment of the legal rights under Section 27 of the Limitation Act. Then your right commences when he sends you a notice that you are my tenant. You may take up the plea. Sorry, I am not your tenant. For 12 years, I am asserting myself as the owner in adverse possession. Huh? That is adverse possession right you are asserting from the date. That suit should be filed within 12 years. So that is what. Then estoppel, 117, estoppel of a acceptor of a bill of exchange, bailey or license. No acceptor of a bill of exchange shall permitted to deny the drawer had the authority to draw such bill, endorse shall bailey or licensee permitted to deny the bailer licensee when the bailment license contain authority to make bailment or grant such license. So these all under the Indian Contract Act, you have learned this. Under the Negotiable Instrument Act, you have learned it. The acceptor bill of exchange. If you had authorized your bank to do transaction with somebody, your counterpart in Dubai or London, America, and he withdraws the money, bill of exchange, waras paper, that you are not permitted to deny unless fraud takes place. Similarly, in the cases bailment of good, if we have deposited the goods with the defendant in good faith and trust, and which is an agent, which is a kacha upadatya, apadit Mumbai, and you cannot deny the relationship of a bailment contract. That is a business transaction, which are normally cannot be jeopardized by taking up the plea. In that event, this called doctrine of estoppel will come into play. 115, 16, 17 relates to estoppel. Please note that here. Anybody want to ask any question before I shift to 18? पढ़ चुके हैं हमने who are competent to testify, who can give. Any Tom, Dick and Harry can file, can come and give evidence. Though you may be forbidden under the Indian Contract Act from contracting. If you are below 18, you cannot contract. If you are below 18, you cannot file a suit unless a minor has to be file a suit with the help of a guardian or a next friend. Similarly, you can only enter into a contract if you are a minor for the benefits. Minor cannot enter into a contract. Minor's contract is ab initio. But a minor's evidence is very good in the eyes of law. See that all persons shall be competent to testify unless the court considers that they are prevented from any understanding question put to them from relation questioned by them, whether my mind's own. A lunatic is not incompetent. A person who is suffering from insanity, lunatic cannot file a suit, isn't it? Unless he has a guardian appointed by the court, isn't it? Unless he is prevented from, but he can give evidence in the eyes of law. Similarly, a child can give that. See, यहाँ पे 118 के अंदर old age में child can give. Any person of unsound mind can give. So under the provisions of Indian Mental Health Act, you cannot file a suit if you are suffering from disability. But if you prove before the court is satisfied, the trial court judge, this man is capable of giving evidence, his evidence can be part. Everybody is competent. 119 says unable to communicate. Even persons who are mute, who are dumb, they can be, through signs they can give. Through signs, intelligible writing can be given. So the Evidence Act doesn't stop a person from giving evidence provided he is intelligible. See the wide discretion. So there is a lot of uh, shift between the paradigm shift in the Evidence Act, CPC, CRPC, and under the Constitution of India, by virtue of Article 20, you are not permitted to incriminate yourself. But under the Evidence Act, you have to give evidence. Okay, 119 के अंदर 120 speaks of parties to civil suits wherein wives or husband or wives or person under criminal trial. In civil proceeding, the parties to the suit and the husband and wife of a party to suit shall be competent witnesses in criminal proceeding against each other, husband, wife in person. So the privileged communication, which is under 122, is when a suit is filed by other people. But when a wife has filed a suit for divorce, a husband has filed a suit for restitution, each other can give evidence pursuant to section 120 against each other. There is no bar. Similarly, under 121, judges and magistrate, no judge or a magistrate shall accept upon a special order from the some court to which he is subordinate be compelled to answer any question as to his own conduct in the court as such judge or magistrate as anything which came to the knowledge in the court as such judge magistrate, but he may be examined as to other matter which occurred with. So there is a protection to judiciary. They are insulated. A police officer cannot arrest a judge immediately without the permission of the High Court or a district judge. You cannot even record the evidence of a judge's magistrate without first approaching the superior judiciary. Because under Article 227 of the Constitution of India, the, the High Court are the superior judges under whose supervision the judges and magistrates are working. So there's this bar, you should know that here. But illustration says that here, in certain cases, they can give. Let us see that on his trial before the court of session, A on his trial before a court of session says that a deposition was improperly taken by B, the magistrate. B cannot be compelled to answer question as to except upon special order. So when you are casting aspersion upon the magistrate or the judge that you are not recording proper evidence, but here you are directly attacking his integrity. So यहाँ पे without the permission from the High Court or the Supreme Court, you are not permitted. You are challenging. Now BC, A is accused before the court of session of having given false evidence. Before B, a magistrate, B cannot ask what A said except upon special order from the court. So here also in a perjury case, where evidence is being recorded, you cannot be casting aspersions upon the judge. So he will not be compelled to answer the question unless the order from the superior court. Now C is important. A is accused before the court of session of attempting to murder a police officer. Whilst on his trial before B, a session judge, B may be examined. So he is a witness to the crime. He is not, the accused is not prosecuting the session judge here, but the accused is attacking the police officer in the presence of a session judge. So at the most, he is a material witness, he can be examined. So he doesn't need permission of the Supreme Court or High Court in this regard. Only 120, section 121 bars the magistrate. So if you tell the magistrate in Bandra Court or Andheri Court or whichever place that you are not hearing my argument properly, my client has no faith in you. This, of course, it's a contempt of court action. And in your presence, so and so happened. I want to examine you in civil court. No, you cannot do that. So you're casting aspersions upon the magistrate or a judge, and deposition is improperly taken. He cannot be compelled to answer question as to except upon the special order. So क्या करेगा magistrate? He will report to the High Court. This advocate was hurling abuses at me and casting aspersion against me. And contempt of court action, he doesn't have powers. He has to report to the High Court. High Court will take action under the provisions of Section 10. So the High Court will direct him whether what he should do. Please note that. Under the scheme of CRPC, that is a 340, 41, 42, a limited power is given to the magistrate. But under the Contempt of Court Act, vast powers are given. Okay. So these are the, when these magistrates can be examined, judges, judiciary, when cannot be. So CPC may be provision, you check it up here. When they can be arrested and when they cannot be arrested. Jogendra Kumar's case is the famous. मालूम है जोगेंद्र कुमार केस 1992 सुप्रीम कोर्ट के अंदर. You cannot arrest judicial officers, you cannot arrest the public servants without the sanction granting bail. Jogendra Kumar's case, please remember it. The guidelines are given when you want to arrest even a minister. What are the guidelines, isn't it? वहां पे दिया गया है, CRPC में पढ़े होंगे आपने ऐसे भी. So CPC के अंदर भी provision है when you want to. Similarly here, as to how evidence to be recorded, whether they can come and depose, whether they are privileged communication governed by 121. So 122 is a communication between marriage. When here husband and wives, what diverge between them, they cannot be examined except in a suit between them. In a matrimonial suit, you can examine. Otherwise, police officer cannot compel the wife, your husband I am arresting. What he was telling you about the crime, please tell. No. It's a privileged communication, you can take it up. Huh? You cannot force the wife, arrest the wife to pressurize her to tell you what exactly did. That is a privileged communication. She is not bound to say anything unless she herself has committed the crime. By keeping silent, Arzwana wrote, you are implementing your the what you call in American Constitution, which right there? What are the rights? Keeping silence. Keeping silence is
Fifth
also your.
Amendment. Fifth Amendment, right?
Yeah, that is a fifth amendment. So it's a state of Arizona, US ka right here. Then 123 is a very controversial subject, which came up for consideration in many cases, including Indira Gandhi versus Raj Narayan's case. That is Gupta's case. Is the Supreme Court has said that evidence of the affair of the state. Normally, the government of India, public officer, they don't like to give you any inspection. They say that it's a official communication. It is a Secrets Act. It's a secret document of the government. But the courts have held that here the public officer, a minister must come before the court, file affidavit. That's a document. See that here? No one shall be permitted to give any evidence derived from the unpublished official record relating to the affairs of the state except with the permission of the officer at the head of the department concerned, who shall give without that. This matter came up for consideration before SP Gupta's case, the first judge's case, second Gupta's case, Indira Gandhi versus Raj Narayan's case. So almost everywhere election matters may have the prime minister, chief minister. This is taken. The Supreme Court has laid down guidelines in way back in the year 1965, 9 bench judges. So affidavit must be given, must be filed by the concerned minister. Huh? That this cannot be withheld permission. If it is not given, and it should be open to public, isn't it? That is how it is. Then official communication. No public officer shall be compelled to disclose communication made to him in official confidence when consider the public interest will suffer. So 123, 124 are synonymous section where the where the minister is required to give file an affidavit under the court of law, especially in representation of People's Act here, that I will give you the citation under section 123 के अंदर. I think I had given you the Gupta's case, no, isn't it? That is a state of UP versus Raj Narayan Lelije, EIR 1975 Supreme Court, page number 865. That was an interesting matter which came up before just the Allahabad High Court, whether I should. In fact, the Allahabad High Court allowed the entire record to be given to Raj Narayan, where the Supreme Court set aside it, unfortunately, in the matter. Then 34, the leading judgment on the point is State of Punjab versus Sodhi Sukhdev Singh, EIR 1961 Supreme Court, page number 493. This is the leading judgment of the Supreme Court, where the Supreme Court laid down the law that the minister is required to file the affidavit. But Justice Subba Rao disagreed in that matter. The minority judgment of Subba Rao Ji is very interesting. Gajendra Gadkar Saab is the senior judge who led the argument in that behalf. He interpreted that this provision is valid and provided the minister file the affidavit. Okay, privilege can only be claimed when the ministers file this. That is affairs of the state here under the Evidence Act. So इसके लिए आप स्टेट ऑफ पंजाब वर्सेस सुखदेव सोदी SS Singh, that is AIR 1961 Supreme Court, page number 463 493 technical, you will come to know the entire history. I think I had given you, discuss the matter while the matter. Then 125 deals with information as to commission of offense. No magistrate or a police officer shall be compelled to say when he got information as to the commission of any offense, and no revenue officer shall be compelled to say when he got information as to commission of any offense against the public revenue. Now, even under the provisions of CRPC, open it up, I'll point out a provision, section 173, खोल लीजिए आप, how the police officer is insulated. Section 154 के बाद 156. Yeah, 156 subclause 2 देखो CRPC. No proceeding of a police officer in any such case shall at any stage be called in question on the ground that the case on which the such officer was not empowered under the section to investigate. He is insulated under 152. Similarly, under the provisions of 125, magistrate and judges are not compelled to say when he got the information. So, in the public interest, because otherwise, if they disclose, it will be sabotage. Revenue officer under the Land Revenue Code, when a person has committed offenses, this is added subsequently in the year, yes. Then professional communication of a lawyer and a client is very, very well known. When a client comes to you that I have committed a crime, you are required to defend him. You are not supposed to judge, अरे इसने मुझे को गुनाह कबूल कर लिया मेरे सामने. You are nobody to accept. Who are you to? You cannot decide that गुनाह कबूल किया. It is the judge who will decide it. You are supposed to defend him, and you cannot tell the court in affidavit, my client is accepting the guna before me, and he wants to plead now. That you are committing, it's a privileged communication. What your client has told you cannot be disclosed. See that here? No barrister, attorney, pleader, or vakil shall at any time be permitted unless with his client express consent. Consent is in writing, to disclose any communication made to him in the course for which purpose employment as such barrister, pleads, attorney, vakil, by on behalf to do thing content of the content. So nothing is to be disclosed even under the provisions of the CPC where you file affidavit of evidence taken up the part 1, part 2, the communication are privileged communication which are refused to disclose. Instructions given to advocate cannot be disclosed. Now that famous explanation, but if the client tells you after engagement, suppose if he has committed if he has committed misappropriation, a breach of trust under 406, 409, for which you are defending him, वो बोलेगा कि during the commission of during the trial proceeding, if the client tells you that I am going to fabricate the will of the accused father, will you defend me? That communication is not protected because you cannot be a party to the crime. This offense which is not committed is not protected. See the illustration? A client says to be the attorney, I have committed forgery and I wish to defend. As the defense of a man to be guilty is not criminal offense, communication is protected. But a client says to be an attorney, I wish to obtain possession by the use of forged document. Now, this communication is not protected because the offense is not yet committed. He wants to do that in future. So, future of offense which is likely to commit, which is going to be to the knowledge of the advocate, is not protected. The advocate can lodge FIR against him. He can get him arrested. But for the offense already committed and come, you cannot do that. Then CA is being charged with embezzlement of rent, retains B in attorney to defend him. In the course of proceeding, we observe the entry has been made is account book charging A with the same offense. Embezzle with entry was not in the book at this one. That being so, B in the course of showing that the fraud has been committed since the commencement is not protected from. So B and C are the example where the offences are sought to be committed subsequent to the engagement of a services of the pleader of a lawyer. It is only those communication are prevented, are protected when it comes to you today that I committed yesterday robbery, please protect me. But if it tells you today that tomorrow I am going to loot your bank, will you obtain anticipatory bail for me? Not protected. You yourself should be informer, otherwise you can be arrested. From the scheme of section 38, 39, 40, 41, every person is bound and liable to report to the police. Okay, that is the privileged communication. Then provisions of 127 shall apply to interpreters, clerks, and servants of barrister, attorneys. So these are the servants of the advocate, your juniors who are working with you, and what because they have your information. All your confidential files are known to you. Your clerk knows you. So the police cannot summon your clerk. Accuse आया था आपके बॉस के पास, सीनियर के पास, क्या बोला? That communication is again protected because the servants are protected. Privilege is not waived by volunteering evidence. If any party to a suit gives evidence therein at his instance, otherwise, he shall not be deemed to have consented such disclosure. Under 126, if any party to the suit proceeding calls any such barrister, attorney or wakil as a witness, he shall be deemed to have consented to such disclosure only if the question such barrister, attorney, wakil on a matter, but for such question, he would not be at liberty to disclose. So, you are enjoined with a duty not to disclose unless permission is given by the client, unless permission is warranted by virtue of the fact that the offense is committed subsequent to your engagement and not before. Then confidential communication with legal advisor. No one shall be compelled to disclose to the court any confidential communication which have taken place between him and the legal professional advisor unless he offers himself as a witness, in which case he may be compelled to disclose any such communication as may appear court may necessary known order explaining the evidence which he has given. So under the provisions of 126, he could not disclose without the express permission. But under the provisions of 129, he can come and depose before the court of law. Confidential communication. In situation like, for example, illustration B and C, where after my engagement, he desired to commit further offenses, they are not protected. Okay, that is all related to the very thin line of insulation which has been created. Protection of a title deeds of a witness, not a party. No witness who is not a party to the suit shall be compelled to produce his title deeds to any property or any document in virtue of which he holds property or pledgee or a mortgagee or any other document, protection of which might tend to criminate him unless he has agreed in writing to produce with the person seeking protection of a document, some person through whom he claims. So you want to prove your immediate neighbor that the defendant has encroached upon your land, or you have easementary rights on the land, that your land is adjacent to the land of the witness. A witness may come and depose. Yes, the fact that I know the plaintiff and defendant very well, I am the neighbor, my house is situate, my land is situate. But in the cross examination, if a question is asked, you are in possession of a land number X, how did you acquire it? You got the conveyance, please produce it. No, you have a right to deny this. They are not permitted to open the Pandora box as against you unless you are consenting. You may feel that you may have become owner by adverse possession. You may have become owner by grabbing some property which you do not want to reveal. The fact that you may be in possession, easementary right of A and B is sought to be litigated, and you are a neighbor, you will come as only a witness. You want to be examined by one of the parties to show that there was a commotion. Between A and B were fighting together. Patthar phek rahe the, and your house was also damaged. In the process, you came as a witness to depose the event, and you cannot be told to bring your documents. Protect your document has some sanctity unless you want to produce on your own. The court will not stop you, but you will not be forced by any of the parties because preservation of the record, your record is important. So 131 में आ जाइए, protection of a document of electronic record which another person having possession could refuse to produce it. Today I will cover 134. Kumar, shall we cover full or stop it till 134?
Sir,
फिर
we have,
huh?
can take another lecture another day to complete the syllabus.
I will complete today till 134. 135 is the last one other lecture because we don't have. Then 131 में आ जाइए.
Sure.
Protection of a document, electronic record which another person having possession would refuse to produce. No one shall be compelled to produce document in his possession or electronic record under his control, which any person would be entitled to refuse to produce if they were in his possession, control, unless such last mentioned person consent to their protection. So in a representation of a People's Act, you are challenging, A is challenging the election of B. So he is producing the mobile phone, CCTV camera, that Gali Gloch hua, Marammazi hui certificate. See, you may say up that he is a volunteer who was also present. You can also check his mobile phone. If he's not showing, you cannot force him. You may check his email. No, you may come as a witness to depose the email, but you cannot force him to produce his email and show it to you what is transpired because his right to privacy will be attacked. His privacy cannot be inquired into. You cannot trample upon it unless he wants to produce the document because he is not a party to the proceeding, but he is a witness. A witness can only be called upon to come and depose to the extent of what he has seen, what he has heard. He cannot be compelled to disclose his own documents and his own he cannot open up his own Pandora box. Okay, you cannot. Then 132, witness not excused from answering on the ground that will criminate. Though this section I had taken earlier to you also. Under the Constitution of India, Article 20, Clause 3 can the witness cannot be compelled to criminate. We giving you the examples of Nandini Satpathe's case. You can at the stage of investigation say I refuse to answer question following your Miranda rights of the USA, right to remain silent. But as a witness, you cannot remain silent. If a question is asked to you, you must answer. You cannot take up the plea that if I answer this question, this will go against me. No. The only remedy is that here, if the answer goes wrong, perjury proceeding can be started against you, but you cannot be arrested. So I explained this 132 very well earlier also. Then 133, accomplice ka evidence, a person who is sought to be examined. So pardon to an accomplice under the CRPC padhe aapne, isn't it? Relevant section, I will once again recapitulate your memory under the CRPC relevant section pardon to the accomplice. किसी को याद है? Section 306. Tender of pardon 306. Then 307 के अंदर power to direct trial. Then 308 के अंदर conditions of pardon. Power to pardon 309. So then evidence is recorded under the section 30-31 में पढ़े of the Evidence Act. When a joint trial takes place, a confession of A against B is valid in a joint trial. If the trial is not held jointly, that is insignificant, and you are not permitted to rely upon the evidence. Accomplice evidence under 114B of the Evidence Act, court said that here, in the cases of may presume, the accomplice is unworthy of a credit unless he is corroborated in material particular. So you require corroboration under the provisions of section 156 of the Evidence Act. Mean, if you want to believe the evidence of a co-accused, दूसरे को भी examine कीजिए, supporting evidence चाहिए. But यहाँ पे section 133 says that here, an accomplice shall be competent witness against an accused person, and a conviction is not illegal merely because it proceeds on uncorroborated testimony. Suppose in a Sheena murder trial case, where the mother and the stepfather killed the Sheena, that lady, poor girl, and the driver was an accomplice, he was given pardon by the prosecution. If he deposes to the fact that here, yes, I was the driver employed by the Mukherjees, Mrs. Mukherjee told me that here we will pick up my daughter from Bandra Linking Road, where she has gone for shopping, and to the college, National College. उनके साथ में मैडम के साथ में उनके एक्स हस्बैंड भी थे. picked up the daughter and शराब पिला के बच्ची को बेहोश कर दिया और गला घोट दिया, और मुझे भी बोले पैर पकड़ने के लिए, मैं भी रखा. Then ultimately the body was disposed of. So he will become an accomplice under the provision of the 306, because the body has been burnt here. The police will not be in a position to dig the evidence. So the evidence of the driver will be in accomplice, will be a good evidence. So the court may believe that he is a competent witness because he was present at the time of the offense. He was in the car. He held it in. So uncorroborated, there is no need to examine anybody else. The court, if believes that his evidence is good evidence, appreciation of evidence under section 3, the court may convict him. But in a case, suppose for example, in a prison, 5-6 people were arrested, एक का murder हो गया, isn't it? They are being tried jointly, and whom to everybody is passing the buck on, मैंने किया, उसने नहीं किया, उसने नहीं किया. So the court is not going to believe the uncorroborated testimony. The court may apply the standard under 114B. The better to have the corroborative evidence, because the accomplice is unworthy. In a situation like this, where in a jail 4 inmates were there, एक को मार हो गया, तीनों में से कोई एक मार दिया होगा, and everybody is proving that he is innocent. And the third person is owning, and it is better to examine independent evidence. Okay, that is then 134 deal with no particular number of witnesses shall be in any case be required for the proof of it. ऐसा नहीं कि you require hundreds of witnesses to prove a fact. A good witness who deposes faithfully and truly, he is known as a sterling witness, best quality evidence witness. He is sufficient to prosecute a man and put him behind the way. Suppose a man is indulging in a lot of falsehood, the witness is not reliable, 60-70 witnesses examine kare, and is of no use. So these are not the quantity, it is the quality of the witness. So number of witnesses you examine is not necessary. It depends upon how many issues. In a civil prosecution, you may take up the plea of ownership, one witness. You may take up the plea of easement, other side, another witness. Another person will take up the plea of settlement has taken place. There was res judicata, then court record. Then customs, you are proving another witness. Handwriting expert, the documents are fabricated, another witness. So each person, each witness, as a examiner, you should know whom to examine. If you are not examining an expert to prove the custom usage, you yourself giving, you cannot become expert. Huh? समझे ना आप? In matters, if you take that my grandfather's will has been fabricated by my brother, and you are not the expert unless you are produced before the court cogent evidence. Fabrication के लिए you appoint a handwriting expert, he will give evidence. In the matter of proving the building will fetch a particular market rate, compensation, mean profit, you have to examine the valuer. You are not an expert. So evidence must be, the correct evidence must be proved. That. In the matter of eyewitnesses were present at the time of the commission of the offense, you are not examine eyewitnesses. Your prosecution, you will not be able to prove. You are trying to prove res geste evidence under section 6, 7, 8 of the Evidence Act. The cries of the mob who are present. Mob को at least 2-3 members of the mob, you must prove it. अगर नहीं तो आप you cannot be able to prove it. A police officer will not be, evidence will be sufficient. The informer is very important. Informer के साथ में वो mob के अंदर कितने लोग present थे, वो भी important. Food poisoning हो गया, you are required to examine an expert. Injury has been caused, it is a fatal injury, you need to examine a doctor. So it is not, you need not examine 10 doctors, 8 doctor, 2 doctors who is an expert. Somebody is an eccentric person, somebody is suffering from insanity. You need to have the report of Indian Mental Health Act from the civil surgeon. So how many number is? So it is all depends. If a witness has not correctly deposed, then another witness. If one witness has given you good evidence, you don't need to examine 10 witnesses, 2 witnesses. Ek bus. Don't burden the court record. Judges will get bored of your matter. So better to confine to one best witness, 1 or 2 best witnesses, and not to pile up the record by examining, especially in election matters, all property, civil matters. People, lawyers have the habit of summoning hundreds of witnesses. That is unwarranted. Okay, आज का टॉपिक बंद रखेंगे. अभी 135 से लेकर लास्ट नेक्स्ट लेक्चर. Whenever convenient, please let me know, Ashutosh Kumar. Anybody has any question, let me know. I am prepared to ask right now. And we can also fix up the next date. Tomorrow I am not available. We can take it up maybe on Thursday or Friday. Okay, Friday, Saturday, I am okay. बता दीजिए आप, whichever day convenient to you all. Friday, Saturday is better. Sunday, I think everybody want to relax. I won't trouble you on a Sunday. Okay, shall we wind up if everybody has understood today's lecture?
Yes, sir.
Okay,
Yes.
bye-bye. Good night.
Good night, sir.